Hello everyone, thanks for coming. A pleasure to introduce Professor John Burrows. It's a real pleasure. Firstly, I just want to acknowledge the Wurundjeri people of the Kulin Nation and the land on which we gather tonight. I also want to acknowledge all the Aboriginal and Torres Strait Islander nations across the continent and those that are here tonight. I appreciate we can be here on Wurundjeri land tonight. So good evening and welcome to the 2023 James Merralls Fellowship Public Lecture. For those who don't know, I'm Dr. Eddie Kabila. I'm a Larrakia, Wajigan and Central Arundel man from the Northern Territory, and I'm currently the Director of the Indigenous Law and Justice Hub at the Melbourne Law School. So again, it's a great pleasure to be here in Melbourne to introduce tonight's guest speaker, Professor John Burrows, joining us from the University of Victoria Law School in Canada. John is an Ashabi man, a member of the Chippewa of the Naywak First Nations in Ontario and grew up in Cape Croker Reserve. He's a renowned international figure and the Canada Research Chair in Indigenous Law. John has published extensively on major works about Indigenous law. Titles include Indigenous Ethics, Braiding Legal Orders, Freedom and Indigenous Constitutionalism and Recovering Canada, The Resurgence of Indigenous Law and many more. We're lucky to have John come to Australia again to, amongst other things, teach a comparative Indigenous rights course in the Melbourne's Masters program. John has taught in this course for many years, and the opportunity to consider Indigenous rights in a comparative context of settler states from a proud and Ashabi man has a profound impact on so many Melbourne Law School students. Go to the growing number of public institutions concerned with Indigenous rights, from the First Peoples Assembly of Victoria to government departments, and you will find people whose interests were first sparked in John's course. It is commendable that John has consistently looked beyond his own communities and made such efforts over his career and to improve the lives of First Nations peoples across the globe. We have so much to learn from each other in our respective struggles. Professor Burrows has been a generous friend to our organisation since the Hub was set up in 2019, a trusted member of our advisory council who is deeply insightful in the guidance he gives and the values he shares. In our curriculum work, we look not only to Professor Burrows' academic work on the resurgence of Indigenous laws, but his important thought leadership in the establishment of the University of Victoria's joint degree program on Canadian common law and Indigenous legal orders, a world-leading program which centres and takes seriously the role and public benefit of Indigenous laws. As well as spending many hours on Zoom advising the Hub, John has generously hosted many of our students who have made their way to Canada to learn our North American cousins about their relationships between modern Indigenous and settler law. John, it is great to have you here with us in Australia, and again I'd also like to welcome John's wife Kim, who is also with us here tonight, and I want to welcome both of you. So tonight, John's lecture is called The Resurgence of Indigenous Law. He describes this lecture as a discussion on how Indigenous peoples' legal principles can generate rich resources for decision-making in contemporary circumstances. As Indigenous peoples, the value of Indigenous law is well known to us, but I still take pleasure in taking the time to hear John eloquently expand on these issues tonight. As a man who carries both Larrakia Wajigan law from saltwater nations and Central Arundel law from a desert nation, as well as practicing in settler legal traditions, I've seen the value of Indigenous law in my life. I experienced the challenges for many of us who, due to the policies of forced removal in this country, navigate a multiplicity of legal traditions. We work so hard to pass these traditions on to our children and grandchildren so that they can benefit from them and be strong in culture. I've also seen more recently the spark in the eyes of non-Indigenous Melbourne Law School students who travel with me to Darwin as part of a subject until recently, when they heard Yolngu men and women from North East Arnhem land explain the different values of relationships which underpin their conceptions of justice. Our students recognising at once the benefit of these ancient and enduring knowledge systems. Australia has a lot to learn from the conversations about what Indigenous law has to offer taking place in Canada and elsewhere. I'm also a man who lived throughout the Northern Territory intervention in which legislative provisions were introduced which still exist today, which prohibit judges taking relevant facts relating to Indigenous law into account in bail and sentencing processes. Such racist legislation sees Indigenous law as detrimental to and counter to justice. Many of our professions are too complacent and complicit or contribute to these problems. Where Indigenous legal systems are recognised in Australia, the tendency is they are frozen in time and we are expected to perform something that meets white imaginings of us in order to benefit. So can I welcome Professor John Burrows now to give his lecture.
Bonjour, Nirwema Kanadok, Niji Nishnabeg Dich Marzik, Bangiet to go in Inata Nishnabe, Megakuchu Nishmayan, Giganos, Indigenous, Neashi, Negaming and Donjaba, Negigintodem. I pay my respects to the Wurundjeri people of the Kulin Nation and I'm grateful for this invitation that I've been given to be with you. Thankful for that warm introduction, Eddie, and I've really enjoyed being here over the past few days in interacting with the students in the LLM course in Comparative Indigenous Rights. I introduced myself and I want to say how grateful I am to be able to introduce myself in my language in this place. I'm talking about the resurgence of Indigenous law and I'm going to situate my own community's genealogy in relationship to law to understand law comes from kinship, law comes from clan, and it can be passed down through the years, through the generations, and then understand a little bit more about Indigenous peoples in Canada before looking at how Canadian law recognizes Indigenous law, digging in a little bit more to what is Indigenous law itself, and then finally pulling on some examples of Indigenous law's revitalization. And the idea is to see another dimension of law. Of course, law comes from legislatures and parliaments, and courts are given the responsibility of interpreting what the meanings might be when there's disputes about that language from legislatures, and we need judges and lawyers to do that. And of course, the executive arm is important for the administrative dimensions and the enforcement aspects, but that's just a version of law, a very important version of law, but law also is a human function. It's something that all societies do. And I want to talk about that in the context of Indigenous people's law, but also help us reflect on how, yes, legislatures, courts, and judges and lawyers and executive arms, but law is more than that too. It is something that we do. First of all, a genealogy of law. Negigin Dodem. My clan is the Otter clan, and this is my people. And so if I travel from where I'm located, which is about 4 hours north of Toronto, and maybe go to Wisconsin or Minnesota, and I encounter another Otter person, we are related and we have mutual responsibilities in that line. Here is where I'm from, Neashi Winigaming or Cape Croker Indian Reserve, like I said, about 3 hours north of Toronto, 4 hours north of Detroit. And the Anishinaabe people of which I'm a part, sometimes called Ojibwe, Odawa, and Potawatomi, are not only in Ontario here, we're also in southern Quebec, north and southern Manitoba, Saskatchewan, as well as Minnesota, Wisconsin, and Michigan. And so if colonialism hadn't come to our shores and you were thinking about the Anishinaabe people, this would be our territory, very rich in natural resources and of course surrounded by the lakes and waters that you see here on the screen. Close up with my territory here, you can see the rivers that flow into the Georgian Bay and Lake Huron, these Great Lakes, and you can see the darker shaded areas are our reserves, and my reserve there, Neashi Winigaming, is on the eastern shores of Georgian Bay, where my mother and sister and family still live today. I actually grew up off of the reserve in this traditional territory, and I recently found out I grew up on Otter land, which was a wonderful discovery. So this is our territory. I also mentioned that my name is Giganos Indigenous. So Giganos is the third great-grandfather's name that I carry. And when I was going to graduate school, I wrote about 7 generations of our family history, the challenges that we faced as people came from different parts of the world, and how we continued to practice our legal traditions and our governance traditions in the face of that arrival. And so here on the screen before you is a man named Tecumseh, or Tecumseh, which means to walk across. And our family stories are is that he's my third great uncle, married to Wasega Boa, who is Giganos's, my third great grandfather's sister. And he was a person that wanted to create alliances when there were people coming into our territory so that we could bind together, take the opportunity to work with the British to try to challenge what was happening with the growth of what became and what was at that time then the United States of America. And so as he walked up and down the seaboard, bringing our law, our ways to others, we helped to push back the United States. And so the United States did not form in places like Quebec and Ontario, not just through the forces of the British soldiers, but also through what our warriors did alongside that through those alliance building pieces. And so in some ways, Canada is as it is because of the actions of people like my ancestors. The other part of the story is we had the settlers come amongst us and introduce Christianity. And sometimes that could have been a challenge to our way of thinking about the world. But in fact, when my great-great-great-grandfather met the Methodist missionaries, he found a coincidence between them. And we have his stories that were recorded. And so in this master's thesis that was eventually published in the Osgoode Hall Law Journal, I tell these speeches, and the idea is that we can join together to climb together up what he calls the tree of life. And so it was a wonderful thing to see that sometimes those relationships which have been adversarial can actually be mutually reinforcing. And so our ways weren't extinguished through war, our ways were not extinguished through Christianity. And of course, a lot of people came into our territory during that time. And part of this work of building alliances was welcoming people into the territory. And that is an important part of the preservation and the reserving of Indigenous law and governance within the place. This is the next generation. You can see my great-great-grandfather, Peter Giganos Jones. He also was a chief of our community, and you can see around his neck 2 medals. One is a treaty medal because he entered into a treaty in 1854 as part of that territory I showed you earlier. And he has another medal because part of the treaty responsibilities was to share the land in accordance with our law when people came to live amongst us. And one of the surveyors that was setting out the plots of land got into trouble. He was wounded, was injured, and my great-great-grandfather loaded him up on a sleigh in the deep winter and walked a couple of 100 kilometers to what is now Toronto and provided aid and assistance such that this man's life was saved. Sometimes people say treaties are something that's extinguished your rights or got in the way of your governance or your law, but in fact, building alliances through treaty was a part of that process that continued our law. And so when he signed the treaty, he put a little otter, Dodim, on the document. And you can see that figure on the document, understanding that that's our relationship and we're wanting to see people live in accordance with the laws that also flow from those clans, as well as learning from and benefiting what was coming amongst us. On the other side of the page are stories from my great-great-grandmother. And these stories were written down by a woman named Verna Patronella Johnson, a great aunt of mine. And in the preface to this book, she says she heard these stories from her great-great-great-grandmother. In other words, 5, 6, 7 generations in the past, we have these stories recorded. What does this have to do about law? Well, our law is found within these stories. And though they might be how the skunk got its stripe and how there's medicines in certain plants, within those stories are facts. and issues and decisions and resolutions of those decisions. And when you look at those stories, you can see our normativity. You can see the standards, principles, authority, criteria, measures, signposts, guideposts, principles and processes for regulating affairs and resolving our disputes. And so the preservation of these stories is our common law. And it's so important to recognize that despite the challenges that came amongst us, those stories circulated all through those years and continue to circulate. My great-great-grandmother was also a linguist, speaking French and Anishinaabemowin as well as English. And language is really critical for the preservation of Indigenous law as well, because there's an entire worldview wrapped up in the language. Anishinaabemowin, which I spoke earlier, is part of the Algonquian language family, which stretches from the Atlantic coast out to the Rocky Mountains with different nations, Mi'kmaq and Passamaquoddy and Innu and Cree and Blackfoot, and again I said Potawatomi, Odawa, Ojibwe, and the words, 70% of our language is verbs. And so if we talk about law and Anishinaabemowin, we're talking about action. And so we think about law as something you conjugate. You add pronouns to it. You add tenses to it. You add locative, location markers to it. It's not so much about the categorization, the nounness of, the abstraction of nouns. It's about what is put to place in action. And so these stories and the language help to preserve this. And my great-grandmother was also a medicine woman. And within our knowledge of the plants, we learn about how to practice law because we reason by way of analogy from the more than human world around us. That is, our professors are the fish and the trees and the rocks and the insects because of the way we see their activities, because of the stories that are attached to them, the way we describe them in our language. The archive of law is written in the way that we see their activities, and the literacy that's involved in reading that kind of law is part of our community because of what people like my great-great-grandmother helped to preserve. Here's the next generation. This is Charles Giganos Jones. He was the most loving figure in my mother's life. As she was growing up, she got to be with him till she was about 10, 12 years of age. And he was a hereditary chief. But the challenge in this generation wasn't the wars, it wasn't the settlers, it wasn't Christianity, it wasn't the treaties, it wasn't necessarily language loss or stories being taken away. It was an Indian Act that was introduced that was designed to assimilate us, make us into the Victorian type citizens of that era, and that purported to change how we would govern ourselves, how we would hold on to land, how we would deal with our children. It was a struggle, it was a challenge, but people like my great-great-grandfather became from hereditary chief to elected chief. Right, and yes, that was challenged to move in that way, but people continue to still reference their values acting under this new system that came amongst us. It constrained us, it pushed us back, but we weren't just passive victims in the face of that legislation. We were also active with our agency, taking up what little space we could, but still nevertheless taking up that space in accordance with our normativity, in accordance with the way that we wanted to best pursue our paths. And so as a part of this work, in putting this together, I interviewed our elders in the community, my great uncle Fred Jones and my aunt Irene Akawenzi and Chick Johnson and John Najuin and others. And then from that oral history, I went to the archives and correlated and triangulated and cross-referenced what I saw in that oral history. And in this particular set of archives, all the band records had been recorded by secretaries. And so I could see what they were deliberating on. And in those deliberations, yes, you saw the influence from Ottawa, but you still saw our own concerns and our own ways there as a part of that governance system. This man was also a runner within our tradition. Giganos, my name, His name means speaker. It's a diminutive of speaker. That's next to the little speaker. In other words, it's a function of political office that when people say things, someone has to keep record of what's said and then pass it along in case there's disputes in that instance. And so Giganos, part of that responsibility was to be a runner with those messages, and he could run between what's now Toronto and Detroit in about 8 days, and he could run between what's now Toronto and Ottawa 6, 7, 8 days. And he could do that because his mother taught him about all the plants and the medicines that line the way. The grocery store was just there as he went, and he was a very fit individual to do that as well. In fact, when he was 98, he came out of the bush with a deer across his neck. He was that strong to be able to still provide for the family in that way. And so he passed along many Anishinaabe laws because of his love, because of his fulfilling of those responsibilities as a runner. Yes, being elected under the Indian Act, but the Indian Act not defeating some of those hereditary dimensions that still carried through. This is my grandfather. His name is Josh Jones. He grew up on the reserve, and there were other challenges in this generation. Abuse became quite rife as people came to educate us. And we've had whole royal commissions and truth and reconciliation commissions surrounding the abuse that was received by our people. And no doubt that challenges a legal tradition, and no doubt that challenges the ability to carry on with law. But again, we're just not passive victims in that sight, right? We still have elements of agency. And so he ran away from the reserve at age 16 to try to escape that abuse. And he became another kind of runner. This time, though, he was working between Detroit and Windsor, and he became a rum runner. It was during the temperance era in the United States when it was illegal under the Constitution to traffic in liquor, and so he trafficked in liquor back and forth across the St. Clair River. And in so doing, sort of staked out his own piece of resistance to what was happening in our territory. But he kept running. He then went down to Kentucky and he taught some biologists about our knowledge of medicine in those sites. And then he kept running. He went out to the West Coast. And in the 1920s, late 20s and 30s, he became a Hollywood Indian. And so for a number of years, he was acting in the films. He was a part of Universal Studios. He was a part of a group called the First Americans. And the First Americans formed a union of different Indigenous peoples, many of them speaking Algonquian languages, and so they could talk with one another in LA and share stories about what the challenges were around the continent. And so that was a part of his life for a period. But what did he do? He ended up getting shot and falling off horses and reinforcing stereotypes that were there more generally circulating in the broader population. And so he's trying to escape the challenge, and he ends up falling back into another challenge. And as he's there, Pearl Harbor is bombed in 1941, and people that looked like him didn't feel safe anymore being in that space, and so he loaded up his family, Grapes of Wrath style, in an old jalopy, and visited with friends that he got to know in Arizona and Oklahoma, and went sort of the Indian country trail, arrived back home on the reserve, and lived out the rest of his life on the reserve. What I'm saying here in relationship to law is there are many challenges that we received, but there was still action that we tried to take to deal with even the limited context that we're in, which allows for a continuity of passing on messages that clan and community might have. When I was a young man, he lived in the bush, just on our hunting reserves, north of our residential reserve, and he did that for about 7 years. And he would come out of the bush maybe every 6 weeks or so to get some tea. And he loved to live in the bush because the challenges he faced sometimes caused him to turn to alcohol. And when he was in the bush, he wasn't tempted by that alcohol, and so he could live a degree of freedom, which is important, of course, when you're trying to sustain yourself and your ways. And he was a brilliant linguist, speaking the language fluently. My sister, incidentally, was beside him. We're in front of the old family cabin, and she's gone on to do her PhD, and she's been working in our community now for about 25 years, dealing with children who are facing challenges because of family issues in the school and in the home. So I now have my mother here on the screen. She received these teachings and passed them along to me as I arrived to in her arms as a young boy, her stories, her way of looking at the world, her understanding of our teachers being the robins and the hawks and the fish is just a part of my life because of the way that she was able to bring that out. Sometimes it's hard for people who are not from our community to understand her because she just speaks so metaphorically and she speaks so relationally that you wonder where she goes, but if you know what she's saying, it's just a rich treasure trove of information about our law. It's also important to note that through these generations, our people married people from other parts of the world. And so you can see my great grandma Ella there from England, and my grandma Una from America, and my father Joseph from England. And the point to say here is that sometimes people challenge us around what our identity is when we're intermarried with other nations. We've been around people for 400 years. The French came into our territory in 1615. We were multi-ethnic people prior to Europeans coming, because Anishinaabe people married Mohawk people and Cree people and Dawa and Potawatomi and Ojibwe. We were multi-ethnic before European arrival. And of course, we were multi-ethnic after European arrival. In other words, we are First Nations. We are not a race. And understanding the First Nation dimension of our laws as they flow through those alliances, flow through those treaties, flow through those stories, that language, flow through those running traditions, flow through the love that still somehow managed to survive, is important to figuring out the resurgence of Indigenous law as First Nations and the political and legal responsibilities that we have in this space and how others can become a part of that in different dimensions. So that was my genealogy of law that I published in the Osgoode Hall Law Journal, indicating that clan and kin and community are still an important site of law. But life goes on, and I have daughters, and this one that you see with her back to you, her name is Gigata, which is a derivation of Giganos, the family name, and she's got her jingle dress on, which is a dress that comes from our tradition of dreaming. And in our powwows, powwow is a contraction of pawajige, which is our word for dreaming. So at these dances, we dance our dreams to try to ensure that we can express what our relationships are to one another, the more than human world, and our ancestors, and those yet to come. Now, this daughter is also a law professor. She's been working at Queen's Law School in Kingston, Ontario now for 1.5 years, teaching classes in Indigenous legal research methods, teaching classes in Indigenous legal environmentalism. And it's wonderful to work with her. We teach classes on the reserve, and there's my mother and myself and my daughter through those 3 generations of bringing out those lessons, and students come from the University of Toronto and Osgoode Hall Law School, and then another week McGill Law students will come, and maybe Western Law students from London, or maybe we'll go to Windsor and visit the Walpole Reserve, being a part of the ongoing genealogy, the jurisgenerative dimensions of law. But there's another daughter there. She's in the small corner. Her name is Megan, or Chick Chick Chigatase. Chick Chick Chigatase, that's her word for chickadee. It's a little songbird. It has a black head and a white body. And during the winter, they're in the trees with the deep snows, and they call out to one another. And the voice they use is they go, she may, she may, she may. The idea is they're looking out for one another in the midst of the vulnerabilities that they face. And if you go to our daycare on the reserve, you'll see emblazoned across the building our word for little brother and sister, which is shime. Right? So we take the word for little one, little brother and sister from the call of the chickadee, and my daughter here, Chick Chick Chigadase, has that name, and she has autism. And a person with autism can practice law tremendously so because they see patterns that we might not see. And they can see where there are departures from patterns that can be troubling. And so what she calls out about what she finds in relationship to vulnerability helps us know how to practice our law in that site as well. And so I'm so grateful for this next generation teaching me about what law might mean. But the generations continue. And so now I have grandchildren. And on the one side, you see Wasea. That's a family name. Wasea means shining bright and clear. It's my second great aunt's name. And she's definitely that sky name with that shining personality. And the other one is Akika. Aki means earth. Ka means the fullness of the earth. Akika. So we've got a sky name and an earth name, bringing about, again, the jurisgenerative possibilities of how we would relate to one another. And it turns out there's another child on the way, a little grandson in February. Who knows what that one will be called? But it's important to see law not just through legislatures and courts and lawyers and judges and executive officials, but also see another dimension of law, which is clan, custom, kin. My colleague, Jeremy Weber, who used to be a law dean at the University of Sydney Law School, talks about the grammar of customary law, that all legal systems rely upon not just the positivistic, but rely upon the local in terms of the way that we have patterns of behavior around expectations, things that if we abide by those expectations, we discover we get to participate more fully in the opportunities of the society. And if we depart from those expectations, then people are maybe not going to form their relationships with us in the same way. We're not going to be able to have that economic opportunity or that visiting opportunity, or we won't be told something as a result of not being in that place of following those patterns of expectation. And the grammar of customary law is not something that's just an Indigenous law. It actually, I think, is the glue that holds together our broader legal system. All of us probably know of many jurisdictions where there's brilliant constitutional provisions and really fabulous cases that interpret those provisions. But on the ground, people aren't living or following or acting in accordance with them because you need something further. People picking up and internalizing dimensions of what's there in those proclamations from legislatures. So that is one way of thinking about law. Indigenous peoples in Canada are very diverse. There's 11 language families. You can see 5 of those language families are on the east side of the Rocky Mountains, and 6 of those language families are in British Columbia. And some of those language families are isolates, meaning they're as distinct from one another as Korean might be to English, right? Because they've just developed there for tens of thousands of years. Within those 11 language families, there's 50 different languages. And so we have to deal with the diversity of Indigenous peoples across those linguistic families, but that is here to show the possibilities for learning and the richness. Of course, this is a challenge for reconciling laws. It's a challenge for harmonizing laws, but it's also a great opportunity because that diversity presents different views of life as to how we set standards, principles, authority, criteria, signposts, guideposts, measures, precedents. There's intellectual and cultural resources in all of those language families for regulating our affairs and resolving our disputes. And so that is a part of the richness of which we find ourselves in. We are organized as Indians under the Constitution, as we call ourselves First Nations. And you can see there's over 600 First Nations in Canada, 650 some odd, and we live on reserves. And you can see the way that the tribal councils and the political orientation of these communities orient themselves is largely on the provincial lines that are there on the map. And so a lot of the advocacy that occurs is ancient, but it's also something that's picked up in this contemporary context. And in fact, our first First Nations Premier of Canada was just elected in Manitoba. Wab Kinew is one of the folks that's participating in that central part of the country. So that's Indigenous peoples. What's the framework of law in Canada? What's our constitution? And I argue that we have both a colonial constitution and an Indigenous constitution. Those colonial constitutional ideas are when we're in the mode of discovery and terra nullius and conquest and adverse possession and occupation, getting in the way of fully living our possibilities. But there's also an Indigenous constitution which is formed through our treaties that we made with the Crown, formed with the alliances that we've made with others, formed in the place, homegrown, not just transported from England, but made real and different because of the encounter of circumstances that are required in the place. And so in our Indigenous constitution, the idea is to find through persuasion and intermingling how Indigenous peoples' laws can come alongside parliamentary laws in the common law. And we had a constitutional amendment back in 1982 that recognized and affirmed existing Aboriginal and treaty rights. And as the courts have interpreted that constitutional provision, they say that that constitutional provision is designed to bridge legal cultures. They say the purpose of that constitutional provision is a reconciliation of the pre-existence of Aboriginal sovereignty with the assertion of Crown sovereignty. And this reconciliation that bridges legal cultures, the court has said, is intersocietal. The court says a morally and politically defensible conception of Aboriginal rights has to incorporate both legal perspectives. So when you practice in this field where Aboriginal and treaty rights are involved, property law can be helpful by way of analogy, but it's not determinative. Contract law, helpful by way of analogy, not determinative. Likewise, tort law, international law, helpful by way of analogy, not determinative. Ojibwe law, helpful by way of analogy, not determinative. Blackfoot law, helpful by way of analogy, not determinative. Inuit law, helpful by way of analogy, not determinative. What's determinative? A morally and politically defensible conception of rights will incorporate both legal perspectives. And so we have to practice multi-juridically. We have to practice transsystemically. We have to compare and contrast and find where those meeting points are, where that nexus is to benefit from the wisdom of different peoples coming together in a place where we have all sorts of challenges around child welfare and environment and over-incarceration, and we're not lacking problems, but we have a framework that starts to deal with those problems. That framework is an old framework. This is my PhD. When I was working on my PhD at Osgoode Hall Law School, I looked at our treaties that were woven. And the periods from about 1764 up until the 1860s. And you can see these treaties are images that are formed from different colored shells put onto hide. And in those images, you see what the relationship of the parties should have been and was for a period of time, which is linking arms together, right? Anishinaabe people standing beside Cree people, standing beside Mohawk people, standing beside the British, and welcoming that British ship ashore. And if we needed help, they would come in our direction. So the reciprocity going back and forth across this covenant chain is a part of those agreements. And so when my ancestors entered into treaties subsequently, this was in the backdrop. And these treaties build upon an Anishinaabe or Indigenous legal technology. So you can't just take the written document in English as understanding what the treaty means. That's evidence of a treaty. The written documents is evidence of a treaty, but something broader was discussed at the treaty that can also be memorialized in other ways. And so the notion of a morally and politically defensible conception of Aboriginal rights incorporating both legal perspectives is an older notion. Right? This is intersocietal. This is multi-juridical, it's multilingual. And it worked for 100 some odd years until we had, and in fact, we're still making treaties today. But we've had many challenges along the way. Legal exclusions, I mentioned the Indian Act, which tried to assimilate us in the way we govern ourselves and hold land. In Canada, we did not have the vote until 1960. And so the ability to participate in the broader political framework was not available to us. In fact, in some provinces, we were the majority of the population when Confederation came about, and when the franchise was set, the majority of the people weren't enfranchised. It was the smaller, much smaller group, British descended, that were exercising that power, and so we were shut out from being able to do things with that political dimension. Our religious freedoms were outlawed. Our dances, our feasts, our giveaways, our potlatches were taken away by the Indian Act in this period. And then our economic pursuits were also outlawed. You had to have licenses, or you couldn't fish in this area or hunt in this area, and sometimes you wouldn't be granted the license to hunt and fish, and you'd be prosecuted. So imagine you were there in the 1880s and you want to do something about the challenges that you face, and the Indian Act is trying to change how you act with one another at home, and you're prevented from going to the ballot box. You think, well, maybe we can get some sustenance from our religious and spiritual traditions, and those are being cut off, and maybe we'll just go out and make a good dollar, and that's being cut off. And then our children are taken away to boarding schools, to residential schools in large, large numbers, trying to save us from ourselves. They wanted to benefit us by teaching us how we could be within the broader society. But when people went through those schools, they often came up with an only fifth grade education, even though they might have gone through grade 12. And it was also the case that they were punished for speaking their language. They weren't allowed to visit their families for 10 or 15 years. They were made to feel ashamed of being Indigenous. And so when you leave the residential schools, it's hard to go home. It's hard to get a job in the broader surrounding as well. And all the while, abuse upon abuse is taking place there, culturally, of course, but also physically, lots of corporal punishment and lots of sexual abuse in those schools as well. We're concerned about that all along, and so we start to organize in the 1910 and 20s to take these questions to our highest court of appeal at the time, the Privy Council, and the Indian Act is amended to make it illegal to raise funds for the purposes of land claims or to consult a lawyer. Right? So you can't go to the ballot box, you can't go to the court. It seems as though there's no accountability that's present, and those treaties that we made with all those promises, they start to wane. And then, of course, the policies of explicit assimilation grow in that period. When we complain about it, sometimes people are taken off the banned rolls, agitators, so you're no longer Indian. And if you can't live on the reserve, you can't participate with your family. You can't have those treaty rights that you negotiated. And then sometimes if the reserves were cut down in their lists of membership, the next person would come along and say, there's too much land here for the small amount of people. So the reserves would be cut off further as a result of this process of trying to limit us. Many Indigenous communities are matrilineal, matriarchal, matrilocal. And what happens in this context is if you're an Indian man and you marry a non-Indian woman, she gains status. But if you're an Indian woman and marry a non-Indian man, you lose your status. And so many, many Indigenous women lost their status through this period, meaning we lost our chiefs, and we lost our property holders, and we lost our wisdom keepers as they were statutorily excommunicated through that process. We go off to fight in great numbers during the First and Second World War. Often 90% of our communities, like our community, 90% of our people sign up. But when they come home, they're not allowed to participate in the education funds that are there for veterans. They're not given land rights that other veterans are given. And so the discrimination that they fought against ends up in their backyard in that period. Inuit people are relocated all over the Arctic in this time because of the Cold War, the DEW line, the distant early warning line, saying we need to have sovereignty in the north. So how do you do that? You move Eskimos in these different places and thousands of kilometers away from their home. You know, living in any ecological environment requires specialized knowledge. Just because you live in a snowy and cold place doesn't mean you can live, 100 kilometers, let alone 1,000 kilometers away from home. And so a lot of suffering occurred through these relocations, and the sled dogs were killed of these people, which of course they used to rely upon in their land. And then as this unfolds in the 1950s and 60s till today, you get a huge rate of over-incarceration, such that on the prairies, you have a greater chance as a young Indian boy or First Nations boy, you have a greater chance of going to jail than you do going to college. And on the prairies, maybe 10% of that population is Indigenous. 90% of the people in jails are Indigenous. Same goes with child care. Children, 80 to 90% of the kids in care in those jurisdictions, despite only being maybe 10% of the population. British Columbia, where I live for part of the year, maybe there's 6 to 8% of that population that's Indigenous. 64% of those kids in care are Indigenous. So the challenges that are there in the past are present with us today. So what do we do about that? Well, we recognize that a morally and politically defensible conception of rights will incorporate both legal perspectives, and we recognize that despite all the disruption, there are still lines of authority through the stories, through the treaties, through the families, through the language, through the alliances that we've created. And so what you see is the revitalization of Indigenous law. We have treaties as modern legal technology in Canada. You can see treaties here that have been signed since 1975. It's like 40% of our land mass. Treaties are not about what once was once upon a time. These treaties are about constitutionally how we organize ourselves off into the future. And if you look at these treaties, they're 200-300 pages, and they deal with authorities for citizenship and forestry and fisheries and mining and social services and business licenses and education, and it's harmonized, right? You have the federal government and the provincial government and the First Nations government harmonizing their laws to deal with future conflict through patterns, processes, and then there's administrative tribunals if you still have further conflict about what's there in those agreements. We have many constitutional doctrines that have been promulgated by the court to recognize and affirm these relationships. There's a doctrine of the honor of the crown, which actually doesn't flow from the Constitution. It flows from the nature of the relationship between Indigenous peoples and the crown. The Constitution recognizes a common law idea. Same with fiduciary duties in this setting. There's principles of reconciliation, sui generis, intersocietal. I don't have time to read all these doctrines. At the University of Toronto Law School, I teach all the first year students, 210. I have 3 sections of 70 students. I meet with 70 of them for 3 hours, 9:30 to 12:30 on Tuesday, and then 9:30 to 12:30 on Wednesday, and 9:30 to 12:30 on Thursday, and through 3 hours a week over 13, 14 weeks, this is what we study alongside Anishinaabe law and Salish law and Blackfoot law. And at the University of Victoria Law School, the degree is a joint degree program. You can get a JID, a Juris Indigenous Doctorate, alongside a Juris Doctorate. And we teach transsystemically. Like at McGill Law School, you can learn how the civil law and the common law interact together. At the University of Victoria, I can teach Anishinaabe constitutionalism alongside Canadian constitutionalism. And my opportunity to teach about Anishinaabe constitutionalism takes me into the United States. What's happening in Minnesota, Wisconsin, and Michigan, as well as what's happening in Manitoba, Quebec, and Ontario. I have a colleague that does that with Cree law and criminal law, and another one, Gitxsan law and property law, and Silcotin law and contract law, and Hulkaminam law and tort law. And the students get intersocietal courses as well in business associations, administrative law, and family law. And in the third year, they get an entire semester in the field, working with an Indigenous legal tradition, first of all, being educated in that, and then applying that law through projects that are presented by the community, and then the students present back to the community what they've learned in that context to try to clinically help advance that. And they do that in the third year, and they do that in the fourth year. And so when you've graduated, you have all the common law dimensions that are necessary to article or clerk and then called to the bar. But you also have dimensions of Indigenous law to know that you just don't go and cut and paste in those communities. You learn skills about how to listen and what different possibilities are with that legal tradition. Our government has implemented the United Nations Declaration on the Rights of Indigenous Peoples federally. The law here is to affirm the declaration and ensure that the laws of Canada are consistent with the declaration through an action plan and through monitoring and reports to Parliament. There's also provincial legislation in British Columbia that does the same thing, but also allows for negotiation to implement aspects of the declaration and allow for Indigenous peoples to exercise inherent rights in accordance with their own governance powers, but also take on ministerial powers at the same moment. So there's a delegation of authority from the minister through those agreements. But from the First Nations perspective, they're not just acting through delegation, they're acting in accordance with this genealogy of law that's come through time in many ways. We had a Truth and Reconciliation Commission as a result of these abuses that occurred in residential schools, calls to action to the law schools, calls to action to law societies. I'm a member of the British Columbia Bar. This past year, I had to take 6 hours of continuing legal education credit as a part of my 12-hour requirement for the year. And all lawyers in British Columbia have to do that to be able to better serve our clients, because so much of the land that we interact with is Indigenous lands. And these calls to action were not just to governments, they were to civil societies. So to museums and businesses and healthcare, and secondary and primary education, as well as to the justice system, as well as to Parliament and legislatures. So there's lots happening as people are taking these processes and revitalizing laws. As they come to the law school at UVic, we have an Indigenous Law Research Unit. By way of invitation, people will present questions to us, and we will help them through their own normativity address the revitalization of law. Law is something you do. It's a verb. It has these dimensions of standards, principles, processes, criteria, measures, indicia, benchmarks, precedent, guides, intellectual, cultural resources, regulations, rules, codes for making decisions and resolving disputes. Right? This is not to take away from legislatures. This is not to take away from courts, but to say law is more than that. And in this context, but also in our broader context, we need to be more explicit about these dimensions of our law. We can understand the sources of Indigenous law, and then we can see on the ground these practices being revitalized as people sing their law. They dance their law. They wear masks, button blankets. They tell stories of how they came to that territory that are thousands of years old that contain guidance about how to live today. We reason by way of analogy or we distinguish. We have people writing these down in constitutions in their own language and choosing different measures and markers for that law. Rather than life, liberty, security, equality, or peace, order, and good government, it's love, truth, respect, wisdom, humility, honesty, bravery. You have tribal court decisions that try to implement those things, just like we try to implement peace, order, and good government, or life, liberty, and security, as the case might be. Environmental assessments are designed by Indigenous peoples to say to a proponent, if you're coming to us and wanting to see development, here's our law. And so the ground upon which the impact benefit agreement might be made, the ground upon which you would decide whether or not a mine would be sited there or the type of remediation that's required would draw on language, stories, draw on principles, draw on elders, youth, counsel from the human world and the more than human world. Some of these treaties, some of these ways are blending Westminster forms of government with traditional forms of government. This is the Niska Nation. They signed a treaty with the Crown in 1993, and when I was working back at the University of Toronto a number of years ago, one of the assignments that my student had was to take Robert's Rules of Order and translate it not linguistically into Niska, but what needs to be modified in Robert's Rules of Order to take account of the house system and the clan system that's present in that site. There's legislation that recognizes many heads of power, including national legislation that recognizes we have an inherent right to self-government in having responsibility for our children, and that's resourced through this legislation. There's also Indigenous courts. So I think we have about 10 or 15 minutes for a conversation, thinking through these questions of the resurgence of Indigenous law, but also think about what law is more generally. What is instructive about this that might actually also be picked up not just by Indigenous peoples, but thought about more generally across our population. So I think I have an opportunity now to sit here and receive a few questions, and I look forward to that. Miigwech, thank you.
Thanks, John.
Thank you.
Appreciate it. Got a question right there, look.
Thank you so much. In the Westminster system, there's a government and opposition, there's a majority vote, and enacted law, at least of that kind, comes out of that process. In the Indigenous law processes, with all the richness that you're describing, there may not be unanimity within a community or even within the tradition. Even within a family, you may have a different version of the story from your sibling or your cousin. Is there a standard way, or is it just varying from community to community as to how to resolve, or to, if you have to seek to synthesize some of these things on your environmental assessment or whatever it might be? Is there a process, or could you describe the process?
Yes, it's a great question, because law doesn't just flow from agreement, although agreement's important to law. Law also flows from disagreement, and then the principles that we apply to that disagreement and the processes that we use to at least find ways of disagreeing agreeably, right? So that if there is a majority opinion, a minority opinion, or a dissenting opinion, that they can hold on for the next time they get a kick at a can, right? And those processes are often circle processes where people in council get to hear from those different points of view. And then there might be, after hearing that points of view, a council of elders that would take that question and make the final decision. Sometimes it would be a society, like there's different societies within First Nations that have different responsibilities. So if it was like a family law issue, it might go to one society, and if it was a property issue, it might go to another society. That's the way the Blackfoot people deal with it. And of course, we are not just traditional people, we're traditional, modern, and postmodern. And so we're continuing to enact things that we're learning from others. So you might have a tribunal that's present in the community. You might have a court that's there, or it might be the band council that in fact processes through that disagreement. We have referenda that also take place in our communities as well. And so it's very important to see that Indigenous peoples aren't just seeking the freedom to be different from other Canadians or Australians. We're also seeking the freedom to be different from one another across our nations and within our nations. And part of that freedom recognizes we have differences of opinion, and law must be there to deal with those differences. And if those disputes are stolen from us, and we don't have the ability to process through those disagreements, then they fester because it's like we always have to go outside to deal with it, and that festering is not good for our social health. And so as much of that dispute, sounds funny, right? We want our disputes back, but if we can recapture those disputes and have them processed inside, that helps with the holding on, even though you disagree, till the next time the opportunity comes around to deal with the question again.
Hello. Is there a difference between law and legal?
Yes, and so there are many different ways of thinking about law within
So which
Indigenous
is
communities.
superior?
They are all interactive, and it depends on the particulars as to which is superior in that moment. So it is the case that we have to be aware of the danger of a single story, understand that nuance is sacred, and within our communities, sometimes they'll lift up the law as the defining moment, sometimes they'll lift up the lore as the defining moment. In other words, we have agency, we have choice, we have freedom to be able to bob and weave between alternatives in those settings. It's not starting from an absolute or fundamental or essential or a priori way of approaching these things. It's approaching from the community context, recognizing all those differences.
Okay, and I'm sorry, my last question is, who is Indian? Because as far as I know, there is a continent of India, and we call the people that come from that part of the world Indians also. Also in some of Captain Cook's diaries, he mentioned that some of the Pacific Islanders are Indian as well. So how do you define who is Indigenous and who's not? Because I think we are all intertwined somewhere along the line.
We are. And how you define that is in accordance with Indigenous law, right? There will be standards and principles and authority and criteria. There'll be disagreements around how that gets applied, but there are well-established systems to work out that. And in the Love and Tom's case, the court talked about the narrowness of vision that might be the case if we only try to decide these things on the basis of blood or race or ancestry. We have our legal traditions to be able to determine who is or is not. And it's not Indian, it's Anishinaabe. Who's Anishinaabe? Or who's Blackfoot? Or who's Salish? Or who's Mi'kmaq? And that is the discussion that we're having. And it's sometimes a tense discussion. There's this debate about pretendians that's taking place in the Canadian setting. But if you turn to our laws, we have ways of dealing with that. Thanks for that question.
Thank you for your incredibly generous lecture. It was just wonderful to sit and listen to. One of the most surprising, inspiring, hopeful things about your lecture was hearing about the legal education in Canada, so-called Canada, and the plural legal education that is taught there. And it was just amazing to me to hear that. It's so different from the way that we do legal education here in NAM. And I'm wondering if I'm sure you do, what your insights are for how we can bring some of that into our legal education here at Melbourne Law School.
Yeah, so 32 years ago when I started teaching, there was only 2 other Indigenous academics in the entire country alongside myself, and there were very few Indigenous students coming into this school. And one of the ways that this has changed is when students who are Indigenous come into the school, they start asking for the education to be done differently, and it's an opportunity to learn about what we might do as a result of their presentation of those possibilities. And so that demand creates a bit of a crisis, but then requires a response. And so part of that is hearing from those folks and learning with those folks. And then along the way, some of those people became law professors. My first 20 years, there was again only 3, 4, 5, but in the last 10 years, 12 years, now there's maybe 25, 30 Indigenous law professors in the country, and that requires support through law school, it requires support with graduate training, but we have a critical mass of people, and they don't just want to teach Canadian law, They want to teach the law of their people as well. And so partially it's from the students, partially it's from building that capacity of people interested in teaching, and then it's building those relationships with community. And so this Indigenous Law Research Unit that my colleague Val Napoleon is the director of is that process of learning outside the law books and outside our parliament and legislatures and judges, and hearing from the law keepers, the elders, the wisdom keepers on that side as well. And I have to say scholarship too, writing about it and being peer reviewed in relationship to that. Like I worked out some of these ideas sitting alone in my study after teaching, after going to community, and my colleagues doing the same, and us sharing ideas with one another. So the university can be a setting to generate that, but there also has to be an openness to that, and we're still nowhere near where we should be. There's so much work ahead of us, but looking back over 30 years, my daughter's teaching Indigenous law, right? I couldn't imagine that would have occurred when I started. I was just teaching contracts law, That's right.
So, just on that then, John, I mean, the openness is probably something that's a struggle in this country at the current time. The law's willingness to accept that there is legal pluralism in this country is a question that Indigenous people have asked, and recently we asked a very minimalist request of our nation. And I think that highlights where we're currently at in regards to our legal system in this country. I mean, we've spoken about it previously. Can you talk about some of the,
Yes.
frustrations and?
Yeah, it is frustrating. We've had referenda in Canada. They've not succeeded, and it's been devastating at the time, but time moves along because people are active agents in their world, not just passive victims. And part of the work is bobbing and weaving between opportunities and being opportunistic, as it were, as to where those openings are and filling them as long as you can until that patience runs out on that site, and then you put your energy over into this site or this site. The frustration, though, is real because there's only so much time and so much energy and so many people that can work in that regard, and we would wish for more willing participants. But it's important to recognize it's not just up to other people, it's also up to us. So we can continue to regenerate our laws within our communities, and we can make treaties or revitalize our treaties with the more than human world. Like in Canada, there's a Buffalo Treaty. So the people of the slopes of the Eastern Rockies from Yukon to Yellowstone are entering into treaties with the buffalo. And in entering treaties with the buffalo, to say they're going to come back to their range, they're going to welcome them back to their range, they enter into treaties with other Indigenous peoples. Don't need the state there. We need the buffalo and those teachings, and then we can reach out to our mob in other places, and then if we get a willing government in places, we can advance that further. So part of that treaty with the buffalo, we talked to Banff National Park, the Leroy Little Bear and the Blackfoot and others. Buffalo went into the backcountry because national parks want to see that iconic animal return. And so we had an ally in that. One day the buffalo are going to run out of the park, and people are going to have to deal with the buffalo, not just with the Blackfoot or the Sarcee or the Cree, right? And so we don't have to wait for the state there. There's things that we can do to revitalize our traditions with the more than human world, revitalize with other Indigenous nations, and then maybe look to different arms of government. Maybe if the parliament's not there or the legislature's not there, maybe Parks is there, or Child and Family Services, or the Environmental Office. And then that shuts down because another government comes in or another leader comes in and you sidestep again. In other words, I worry about proceeding from abstract, fundamental, generalized, essentialized, a priori first principles Generalizations are important, right? Hugely important, but they can stop us from the work that might need to occur in another space because we get caught up in the noun. What does sovereignty mean? Or what does law mean? And there's so much verbing to go on. There's so much conjugation that can go on in the different places that we find ourselves. And so we need to mourn these losses, and we need to decry the unwillingness of others to deal with us. We should not let that slide or slip or hold that accounting moment very high in our presence, express those lost opportunities, but there's life in other regions too. And we teach as Anishinaabe people that life is in a circle, it's not linear. And if we want to follow our traditions and we think about our 65,000 years here, 12,000 years in North America, there is a cyclical dimension, and we need to remember that too. Not as an excuse, not to get off the hook, but just to apply our teachings in the present world.
And we have time for one or two more questions. There's a couple of students in the building there. That student there, yeah.
G'day. I was wondering, as you spoke quite a lot about crucial stories that are intertwined with law, and what I can tell is celebration of a lot of those aspects of your culture and identity. And as particularly in Victoria, the treaty processes are ongoing. I was curious your opinion about the importance, obviously, of the social and economic perspectives, but also of reclaiming, re-establishing those other aspects, those cultural, religious, etc. aspects that may have been lost because of colonization.
Yeah, that's a great question. It reinforces what I was saying a moment ago, which is we start in the middle of the mess that we're in. We can't sort of retreat to a first principle or this has always priority over that other thing. We start in the middle of the confusion that we find ourselves in, and we take steps in all of these places to move them as much as we can in that instance. Now, if we have limited resources, as we do, we'll have to make choices as to what gets the attention at this moment, but not ignoring that we need to continue the stories as we're dealing with the economic dimensions, as we're dealing with the social dimensions, as we're dealing with the legal dimensions, because ultimately they all intertwine, right? And if we can see the triangulation, the cross-referencing, the mutually reinforcing dimension of the sphere, that's not then just going to be for First Nations that are cross-referencing and triangulating and mutually reinforcing. There's things that emerge out of that help to triangulate and cross-reference and reinforce some of the other values that we all cherish in our place. And part of what I'm interested in is not just the resurgence of Indigenous law, I'm really interested in the resurgence of the common law. Because it came from a place where there was Angles and Saxons and Jutes and Normans and Celts, and they had courts of admiralty and common pleas and king's courts and ecclesiastical courts, and there was a rich legal pluralism that could process that. And it came across oceans and it became frozen. Sometimes we talk about Indigenous peoples being subject to the state having frozen rights. In some ways, the common law is frozen. And so the revitalization of the common law is very, very important to me, not just for Indigenous people's sake. I want to see us be more participatory, more democratic, taking account of different perspectives, seeing the law as something we all do. So when lawyers work with clients, it's not just us bringing the law to them or Parliament setting what the agenda is, right? We help our client make law because in a contract, they want to do this. In a property dimension, they want to do this. In a marriage context, they want to do that. We need to help people law again. And if we continue to imagine law as unilateral, unidirectional, kind of monocultural, we lose the great potential that the common law system has to be more liberatory. And perhaps the comparison, the contrast, and the working together with Indigenous peoples unfreezes us both is one of my hopes.
Thank you, John. I just wanted to, probably we wind it up now, and I'd like Sam to close the session tonight.
Good evening, everybody. My name's Sam Hay. I'm the immediate past president of the Victorian Bar. On behalf of the assembled audience and also on behalf of the Melbourne Law School and the Victorian Bar, I'm pleased to have the opportunity to thank Professor Burrows for delivering his lecture tonight. We are very grateful that Professor Burrows accepted our invitation to participate in the James Merralls Visiting Fellowship Program and as our 2023 Fellow. It's a joint program between the Bar and the University, and it's one of which we're very proud. Broadening our understanding of Indigenous law in Australia is an important task. For some time now, aspects of Indigenous law and culture have been incorporated into broader public life. Acknowledgements of country and welcomes to country are commonplace in courts, boardrooms, sporting arenas and concert stadia. Of course, in the scheme of things, these incorporations are modest, but they are very important. They reflect the fact that First Nations people have a body of law that is worthy of recognition and, most importantly, respect. And of course, to properly recognise and respect a system of law, one has to understand it and one has to grapple with it. Perhaps at times one may have to be critical of it, just as we are when we analyse and grapple with common law. Having had the opportunity to look at the professor's work at the University of Victoria and having listened to him tonight, it is clear that Professor Burrows' work helps us to perform all of those important tasks. From a societal perspective, it may be hoped that a better recognition of and higher levels of respect for Indigenous law and culture will assist in the urgent task of reconciliation that lies in front of us here in Australia. From a lawyer's perspective, Professor Burrows' work helps in practical ways. An understanding of Indigenous law has become necessary to interpret and apply common law in a range of areas, from native title all the way through to more mundane and practical matters, such as the way in which Indigenous witnesses give evidence in a common law court. For all of these reasons, we are very, very grateful that Professor Burrows has shared his insights with us this evening. Ladies and gentlemen, thank you very much for your attendance and your attention this evening. Could you join with me in expressing our thanks in the usual way?